Child element application is stressful, emotional. However, sometimes it is difficult to afford the legal cost to make an application. In this video, I'll show you how to make a child element application in case if you can't afford the instructor solicitor. My name is Suhail Ahmed. I'm a solicitor at SWF Solicitor. So in this video, I'll show you the form you need to complete. But before I go to there, let me give you some tips and information. Now, child element application is also known to a contact order under Section 8 of Children Act 1989. In child element application is various organization is involved. CAFCAS involved, local authority, social care, court, legal advisor, parents, solicitor, and sometimes police. The primary purpose or primary consideration for the court is what is the best interest of the children, and all the organization is work how the best interest can be served by arranging the arrangement between both parents, that so that the child can't be a victim because of the issue between parents. Sometimes you will feel that maybe the social care is against you. Sometimes you feel this Kafka is not is against you. Well, in my opinion, as a professional from my experience, is not to be the case. What is the everyone work what is the best interest of the child? Yes, sometimes the party fail to establish that they are looking for the best interest, and some prior misconception about other parties. Sometimes the Kafka's recommendation or social care local authority report go against you, but you that's why you are going to go to court to challenge the Kafka's as well, or the social care recommendation. So various report and recommendation report, investigation report, section 7 report, section 37 report, so this will come to the court, and you normally will be directed to give a position statement which whether you are agree with the subsection 7 report. So this you will have option to challenge the local authority in the court. Your lawyer will able to ask the social care or the Kafka's officer in certain circumstances, not in many cases, mostly local authority, you can challenge their recommendation report. So let me how to start now. Before you go to the court, you should attend the Miami, which is mediation information assessment meeting. However, if you apply for an injunction for urgency or domestic violence or for any other exceptional reason, you can straight away make the application by completing C100 form. So this is the form which you need to complete. This is basically your information, children information, their date of birth, your details, whose care children is, whether any health and safety, whether anything urgency concern, whether the children is in the risk of harm. So these are the basic information you need to complete it. This form is quite long. Also, there is another additional form C8. So if you need, you can complete this one. Once you complete the form, you can submit it to the court. You can send it by email. There is a court fee which is 240. However, you can apply for exemption if you are on a universal credit or in benefit, or if you are a job seeker or you don't have enough finance to pay the court fee. Once the court receives the order, court will take into account, and without notifying the party, court will issue fast direction. And in that direction, what the court will do, court will order direct the Kafka's to prepare an investigation report. Kafka's will call you or do a meeting face to face. Kafka's will speak to both parents. Kafka's will go to visit sometime the other party, children, and then they will give a recommendation report. And then will be the first hearing date. You will receive one direction, and on that hearing date, you will attend. You will tell your submission whether you agree or not. This will be a reconciliation types, mediation type. Court will try to, if the court think appropriate, court will try to resolve it without further hearing. In case there is a domestic violence involved, there is a allegation each other, then court might not decide on that first hearing. Rather than court will direct, if necessary, including a fact-finding hearing or the final hearing. In that case, court will give issue another direction, which court may direct the local authority to investigate this matter, which extensively local authority will go to school, local authority will go to children, speak face to face, local authority will speak with both parents, sometimes family members, and then if police involved. So these types of, they will get the information from different sources, and then they will give a recommendation report, investigation report to the court. Again, court will give you timetable to give the position statement, and then it will proceed to final hearing and less fact-finding hearing. I'll do a details another separate video about fact-finding hearing. How does it work? What the purpose of the fact-finding hearing, and how fact-finding hearing affect the contact or the final decision. So this is a brief information. If you are interested, subscribe my channel, and I will provide more update about the further hearing, fact-finding hearing, final hearing, reconciliation, first appointment, and other family law as well. My name is Sohail Ahmed. As I said, I'm a solicitor at SWF Solicitor. If you need any assistance, please feel free to contact with us. Our contact details at the bottom of the screen. We have office in London and Milton Keynes. However, we can provide advice through online Zoom meeting anywhere in the UK.